Hi, everyone, and welcome back to the Texas Business Court Insider. I'm Kate Ergenbright, and I'm here today with my colleague, Rachel Roosth. Today, we're going to be covering something that every Texas litigator needs to be aware of, whether you're practicing in the business court or any other state court in Texas. And that is that the Texas Supreme Court recently completely rewrote Texas Rule of Civil Procedure 166A, which is the rule governing summary judgment practice in Texas. The new version of this rule applies to summary judgment motions filed on or after March 1st of this year.
That's right. And even though the rule was completely rewritten, in many instances, it was not meant to substantively change the law, although there are some instances where that is the case. So today we're going to walk through the most important of these changes and the practical steps you need to take now to stay ahead of them. Kate, why don't you start us off? What do you think is the most significant change in the rule?
So the most significant change is a new set of deadlines for responses and replies to summary judgment motions. Under the old rule, deadlines for filing a response to an MSJ were tied to the date that the MSJ was actually heard or set for submission. Under the new rule, deadlines for the response, a reply, and even the hearing for a summary judgment are all tied to the date that the motion is actually filed.
Kate, let's walk through those differences. What was the old rule and how did it work in practice?
So under the prior version of Rule 166A, response deadlines were tied to that date the motion was actually heard or set for submission, regardless of when it was filed. So motions had to be filed and served at least 21 days before a hearing or submission date. Responses were due at least 7 days before that hearing or submission date. And there was no deadline in the rule for a reply to a summary judgment motion. Now, the practical reality of this is that in large counties where it can take months and months to get a summary judgment hearing, respondents often had a lot longer than the minimum time required by Rule 166A to actually respond to a summary judgment motion.
So what about the new rule? How has this changed?
So under the new rule, the clock starts as soon as a motion is filed, regardless of when a hearing is set. A non-movement's response is due 21 days after a summary judgment motion is filed, and the movement's reply is then due 7 days after that. Those deadlines can be changed upon agreements of the parties or upon leave of court. Rachel, why don't you tell us about the other significant change in the new rule?
Sure. So the other significant change that I think is significant is that courts now have deadlines to hear and rule on summary judgment motions. Under the new rule, the oral hearing or submission date cannot be earlier than 35 days after the motion was filed. The court must set a hearing or submission date within 60 days of filing. But there's a fallback. The court can extend the timeline to 90 days in one of three situations. One, if the court's docket requires it, in other words, if the court's really busy. Two, on a showing of good cause. Or three, if the movement agrees to the extension. And the court must issue its ruling within 90 days after the hearing or submission date.
Now, Rachel, how is that enforced? Is there a mechanism designed for ensuring the judges adhere to those deadlines?
The rule does not directly address enforcement of these deadlines, so it's similar to Rule 91A on motions to dismiss in that regard. There's no built-in enforcement mechanism in the rule itself. That said, there still may be some accountability mechanisms. Under new provisions of the government code, courts are required to report their compliance with this rule at least quarterly to the Office of Court Administration. And then the Office of Court Administration has to issue an annual public report on the court's compliance with the deadlines. Then other changes to the government code suggest that the willful, persistent, and unjustifiable failure to meet deadlines could constitute grounds for removal or discipline of the judge. So we'll have to see how this plays out in practice, but these changes certainly seem to signal that the other two branches of government are taking these timelines very seriously and expecting the courts to follow them. Now, Kate, let's put the potential accountability mechanisms aside for now and focus in on how the new rule affects litigants. What do you think litigants should take away from these deadline changes?
So if you're responding to a summary judgment motion, don't wait to see when that motion is actually set for hearing or what submission date is assigned to the motion before you prepare your response. Start preparing as soon as the motion is filed, because those 21 days are going to come up faster than you think. Now, if you're the movement, you should anticipate that you're going to be getting a response to your summary judgment motion a little earlier than you are probably used to. So build out time in your calendar to prepare your reply within the new rule's deadlines. And make sure that your entire team, including anyone involved in calendaring or setting hearings, is up to speed on these new deadlines so you make sure that you comply with them. Now, given these new deadlines, Rachel, what does the amended Rule 166A say about obtaining a continuance?
Well, a non-movement may seek a continuance if they need additional time to obtain evidence before responding, but they have to file an affidavit or a declaration specifying the reasons why they cannot present facts essential to justify their opposition to the motion. And at that point, the court may extend the time to file the response. The court could also deny the motion with prejudice to permit additional discovery, or it could issue any other remedy that it deems appropriate under those circumstances.
So what does this mean for practitioners at a practical level? What should we be doing differently?
Well, given the new deadlines and these continuance obligations, it's especially important that practitioners consider early whether additional discovery is going to be needed to respond to a pending or an anticipated summary judgment motion. So that way they can have ample time to prepare and obtain the necessary affidavit or declaration. And they should consider negotiating a specific provision in their scheduling or docket control order that prohibits no evidence motions for summary judgment from being filed before a certain date. And that way they can reduce disputes over whether a continuance is warranted or not based on whether adequate discovery has occurred. Now, Kate, can you tell us about some of the other changes under the new Rule 166A?
So there are some new formatting changes which are entirely new. Summary judgment motions are now required to use one of three specific titles prescribed by the new Rule 166A. The first is traditional motion for summary judgment. The second, no evidence motion for summary judgment. And the third is combined motion for traditional and no evidence summary judgment. The amended rule specifically says that if you don't use one of these titles or you use the incorrect title, that's not grounds for actually denying your motion. So this titling requirement appears designed to improve judicial workflow and make it clear to the court what type of summary judgment motion has been filed, and not to create procedural hurdles for parties. Now, another interesting formatting requirement relates to requests for oral argument. So if a summary judgment motion is set for submission rather than an oral hearing, and the respondent wants an oral hearing, they have to request an oral argument in the title of their response filing. So make sure that you update your response summary judgment templates accordingly. Now, Rachel, what else should litigants be aware of under the new amended rule?
Well, one other change is that the amended rule now includes a formal procedure for withdrawing a summary judgment motion. Any withdrawal must be filed and must identify the date the motion was originally filed. The prior version of Rule 166A was just silent on this issue. There are also some changes that are really just codification of existing Texas law and practice. Rule 166A now includes specific definitions for a traditional and a no evidence summary judgment motion, as well as the standards for granting each. And you also mentioned earlier that you can file combined traditional and no evidence summary judgment motion. That is now expressly permitted by the rule, but that was common practice anyway. Now, Kate, I know there are some changes related to summary judgment evidence. Can you tell us about those?
So the rule now includes a new provision specifically listing the type of evidence that can accompany a traditional summary judgment motion. These include deposition transcripts and opposing parties' pleadings, interrogatory answers, admissions, and other discovery responses, affidavits and declarations, stipulations, and other authenticated evidence. While this list is new, these categories of evidence are all categories traditionally used by Texas litigants to support or oppose summary judgment. Now, one noteworthy addition with respect to evidence is there's now a provision in the rule that states that a court can consider late filed evidence if it indicates it's doing so on the record. Now, the rule is silent as to how a court should actually make that indication, but best practice is to get a ruling from the court confirming that any late filed evidence is actually being considered. Now, Rachel, let's focus on affidavits for a minute. What amendments were made related to affidavits?
Under the prior version of Rule 166A, if the court found that affidavits were presented in bad faith or solely for the purpose of delay, the court was required to order the offending party to pay the other party's reasonable expenses. But that's not the case now. Sanctions for bad faith affidavits are no longer automatic. The court now has discretion rather than an obligation to impose them. And another noteworthy change is that defects in the form of an affidavit or declaration will not be grounds for reversal unless the opposing party specifically points it out by objection after the other party has had an opportunity but has refused to amend the affidavit or declaration. So if you believe an opposing party's affidavit or declaration is defective in form, you must identify the alleged defect to opposing counsel first and give them an opportunity to cure it before you go on and lodge a formal objection with the court.
I think that covers the key changes to Rule 166A, Rachel. So any last takeaways you want to share?
Sure. I think if you haven't already, now is the time to update your motion and your response templates. You also need to train your team on these new deadlines and build these changes into your docket management systems because this rule is in effect now. It started on March 1st for any motions filed on or after that date. So if you have not paid attention, now's the time to start.
Well said, Rachel. Thanks for watching the Texas Business Court Insider. Be sure to hit like and subscribe to get notified of our new videos. Don't forget to check out our Texas Business Court Insider Hub via the link below to see our other videos and thought leadership.